Thanks, David, for drawing my attention to the 2024 case of Dworick and Watts 2, and I'll pop the citation down below. This case does a great job of explaining that parental alienation is not a diagnosis, it's a legal construct. By way of a very brief summary of this case, it involved a 12-year-old boy who had been living primarily with his mother. In this case, the court actually made orders to change the residence of the 12-year-old to living with the mum to living with the father. Now, even though the court did find that the mother had engaged in alienating behaviours, that was not determinative. There were many reasons why the court believed it was in the child's best interest to go from living with mum to living with dad. One of the main reasons in this case was educational neglect. So the evidence was that whilst living with the mother, the child had not been attending school to the level that would be expected. And the mother had been on notice for some time that schooling was one of the primary issues in this case. The expert had included comments in their report that they supported the child remaining living with the mother subject to some hurdles, and one of those conditions was that the mother was to ensure the child attended school to an acceptable level. There were other risk issues in this case. For example, the mother had experienced some acute mental health episodes, and it was not contested that those mental health episodes at times were exacerbated by polysubstance abuse. The court was critical of both mum and dad. For example, they were described at one point of the judgment as both having narcissistic traits and being immature. Importantly, in this case, the child had expressed firm views that he wanted to live with the mother, and he had been resisting spending time with the father. The father's case was that the child was resisting spending time with him because of the mother's alienating behaviour. So he was running an alienation case. Mum's position was that the child was resisting spending time with the father due to the child's lived experience with the father, and because the father was aggressive and because of how the father treated the child during his time. What the court looks at is the entire picture. So pursuant to section 60cc, there are multiple considerations the court will take into account. The child's expressed views is one of several factors that the court will take into account, but the child's expressed views is not determinative. And the existence of alienating behaviours in a case is also not determinative. The court will take a look at the entire factual background and all of the evidence when deciding what parenting arrangements are in the child or the children's best interests. So I'm reading directly from the judgment here, and you can see it says, child's resistance to spending time with the father. In considering whether the child's resistance to spending time with the father is due to the conduct of the mother, I agree and respectfully adopt the analysis of Sir Andrew Macfarlane, President of the Family Law Division of the High Court of England and Wales, that the concept of parental alienation is a legal construct rather than a diagnosable syndrome. In Parental Alienation Instruction of Expert, Macfarlane adopted and applied a submission by the United Kingdom Association of Clinical Psychologists that one particular paragraph in the Association of Clinical Psychologists' skeleton argument deserves to be widely understood, and I would strongly urge accepted. Much like an allegation of domestic abuse, the decision about whether or not a parent has alienated a child is a question of fact for the court to resolve, and not a diagnosis that can or should be offered by a psychologist. For these purposes, the ACP UK wishes to emphasise that parental alienation is not a syndrome capable of being diagnosed, but a process of manipulation of children perpetrated by one parent against the other through what are termed as alienating behaviours. It is fundamentally a question of fact. And the judgment goes on to say, most family judges have, for some time, regarded the label of parental alienation and the suggestion that there may be a diagnosable syndrome of that name as being unhelpful. What is important, as with domestic abuse, is the particular behaviour that is found to have taken place within the individual family before the court, and the impact of that behaviour may have had on the relationship of a child with either or both of his or her parents. In this regard, the identification of the alienating behaviour should be the court's focus, rather than any quest to determine whether the label parental alienation can be applied. So the focus is on the alienating behaviour rather than the label parental alienation. The court goes on to say, in this matter, I'm satisfied that the mother has engaged in alienating behaviours. This is evidenced in two video recordings tendered by the mother in proceedings. The first was video footage of the child in a car with the mother and his brother in April of 2021. The video was tendered by the mother with a view to establishing that the child was petrified of the father. The video did not establish such a fear on the part of the child. Nevertheless, the child can be heard responding to a question from his brother to the effect that he hated his father. The mother's silence in respect to such interaction between the child and his brother was regrettable and consistent with the mother permitting the child to form negative views of the father. The court says, There is video footage of the mother again in the car with the child taken in August of 2021. In that recording, the child can be heard to complain about his father imposing a day without access to electronic devices and taking him on a bike ride. The child can be heard to be protesting that his father overexerted him by pushing him on his bike to go a greater distance than he wanted to. The mother can be heard inquiring of the child whether he would like to cease spending time with his father, in which case she explained he would be required to make statements to the relevant authorities condemning the father and his conduct. The child agreed to the mother's proposal. The court says, while I accept that the mother has engaged in conduct with the intention of dissuading the child from spending time with the father, I am equally satisfied that this has occurred in the context where the child's reluctance is also based on lived experience. As you can see, parental alienation isn't a diagnosis. Similar to ABUSE and family VIOLENCE, you don't diagnose someone with ABUSE or with being a victim of ABUSE. It's a finding that can be made based on factual circumstances. So in response to the behaviour, the court can make a finding of fact. There are obviously different degrees of the impact of alienating behaviours. If you think of parental alienation on a spectrum, at the lower end, you might have a situation where a parent is subtly programming and manipulating the children. They might not intend to turn the children against the other parent. They might just be saying and doing things that are subtly programming the child or children. In that situation, the child or children might not have completely rejected the other parent. They might still be interested to spend time with the other parent. And so child therapy or family therapy might be a viable remedy in that situation. Parental education in relation to the short and long-term negative effects, possible negative effects of parental alienation might also be suitable in that situation. Then if you move to the middle of the spectrum, you might have a situation where there's more moderate parental alienation tactics at play and behaviours at play. You might have the parent deliberately saying and doing things to build their alliance with the children and to damage the children's perception of the other parent and their attachment with the other parent. In this scenario, the children might not be entirely resistant to spending time with the targeted parent, and when they do actually spend time with the targeted parent, often their relationship goes back to normal and they're loving and comfortable with that parent. And often this can be identified in court proceedings during the observation sessions, where you might have the children saying that they hate the other parent, they cannot stand them, etc. Then during the observation session, you'll see the children are running up to them, saying they love them, saying they miss them, giving them big cuddles. Then if you look at the severe end of parental alienation or the alienating behaviours, you might have a situation where a parent is making false allegations against the targeted parent. They might be utilising services and making false reports, and they might be telling the children, they might be coaching the children to make false allegations or to say certain negative things against the other parent to bolster or to strengthen their family law claim. And what they don't understand is that they're showing that their own interest, strengthening their family law case or strengthening their position, is more important to them than the psychological harm and impact and damage that they're causing to the children in coaching them and manipulating them psychologically like this. When there is evidence of intentional, serious alienating behaviours and tactics at play, like false allegations, coaching, all of that, you might see a situation where the court makes orders to change the residence of the child or children, to go from living with the alienating parent to going and living with the targeted parent. And that can come often with orders for family therapy, for the child to go to therapy, for the therapist to be provided with a copy of the expert reports and a copy of the judgment. And this is what I mean when I say that the court treats alienating behaviours very seriously, is in some circumstances, and as you'll see in part 3 of this series, they will make orders to change the residence. So the children go from living with the person who is engaging in these alienating behaviours to living with the targeted parent. And sometimes there is a suspension on the alienating parent's time to give the targeted parents and the children time to reestablish that relationship. Sometimes the alienating parent's time is supervised for a period. In this particular case, the mother's alienating behaviours weren't determinative. So that wasn't the entire reason why the court made orders for the child to go from living with her to living with the father. There were a range of issues at play here, the risk issues, the educational neglect, etc. So stay tuned for part 3 of this series on parental alienation, where I provide 3 case summaries where the court made change of residence orders in response to the alienating parents' alienating behaviours, which were found to have caused the child or children to reject or partially reject the targeted parent. As always, this video contains information, not legal advice. I'm a lawyer, but I'm not your lawyer.